Hi, it's Shan Wu with a Undercolor of Law hot take on what might the Trump regime be worried about when it comes to Jack Smith releasing a special counsel report. So first of all, poof, just like that, there goes the Mar-a-Lago documents case as well. Because a federal appeals court has now decided to end the appeal with regard to Trump on that documents case. You remember that Judge Eileen Cannon, the Trump-appointed judge who has done his bidding in the case, had dismissed that case, saying, among other things, that it's unconstitutional, that Smith was unconstitutionally appointed. Obviously, the Justice Department has a strong reason to maintain that appeal about the issue. So, with regard to the other two co-defendants, it probably stays alive, but they have dismissed the appeal for purposes of Trump. That's a very naughty kind of decision for them to make. I don't think they should have done it. Again, I felt they should have just kept pursuing it until Trump came in and got rid of it, and I'll kind of explain that a little bit more in a moment. Well, for those documents, that case involving the documents, that leaves us with a commander-in-chief who left national security documents in open boxes and bathrooms at his resort, where all manner of people and guests wandered freely about it. That means he is free of any criminal accountability for that, at least for the term of his last term as presidency. I don't think it's really practical to think it's going to be revived, but theoretically it's preserved. Now, it should have no effect whatsoever on the state prosecutions, as we've talked about. The Manhattan DA sentencing should go ahead, and the Fulton County, Georgia case should go ahead too, even though it's proceeding at a slower pace. Trump's going to argue that there's a supremacy clause issue, that the federal law trumps or wins over state law. But the problem here is there is no federal law. The only thing that really exists is the Justice Department's OLC, that's the Office of Legal Counsel, their frankly kind of ridiculous rule, which seems designed to protect only those presidents most prone to criminal activity, saying you can't prosecute a sitting president. That's not a law, it's their opinion, unless and until that matter gets to the Supreme Court to perhaps create a more nonsensical constitutional protection for the president. Someone should remind the Supreme Court that the Constitution is meant to protect the people, not to protect the president. So what's left? Well, we have reporting now that Jack Smith will release a report, as the special counsel regulations require him to do, before the inauguration. Also, according to that reporting, Attorney General Garland is going to release the report. No big surprise there. Garland has in the past said he would follow the recommendations of any special counsel to release the report. We may recall that with the Robert Hur report on the Biden documents that he did not do anything to edit it, even though it was kind of a blatant hit job on President Biden. Now, what to watch out for here is what arguments Team Trump may try to make to slow this down, to not allow it to be released. So remember what I was saying about Judge Eileen Cannon finding that Smith was unconstitutionally appointed, and Trump's people like that argument, and they've also suggested that that should be true for the Washington, D.C. election interference case, the January 6th case. Of course, that doesn't matter now because it's dismissed. However, they may use that argument. It's a little bit convoluted, so follow me here. They may use that argument that therefore this report shouldn't be released. It's the idea that if Jack Smith was unconstitutionally appointed, then the special regulations are unconstitutional, and so he shouldn't be able to release the report. The whole process is unconstitutional. You might say, well, why doesn't just DOJ do it separately of the special counsel? Well, the argument there would be that the whole investigation was improper. It's tainted by unconstitutionality, kind of a fruit of the poisonous tree argument, but like I said, kind of convoluted. But that's the argument, to say can't use it at all because Smith's appointment, everything he did was unconstitutional. Now, I personally don't really follow the legal logic there, but I'm sure Trump's lawyers will try to make that kind of argument. And of course, the danger is it drags its way up to the Supreme Court, who might come up with some weak constitutional bogus theory to say that perhaps, at the very least, the report needs to be delayed until after Trump's term. So are there any silver linings to this kind of like worrisome scenario, which may not happen. I mean, they may not be able to prevent it. They may not make those arguments, but that is the argument they might make that I'm most worried about in terms of the delay. Well, there might be some silver linings to it. So first, it certainly makes plain if the Trump regime puts up this kind of fight that they must be very worried about what's going to be in the report being released, which is interesting because he's won the election. He doesn't have any real criminal liability for that anymore. Even if he did, worst case scenario, if he's worried about that, he could try to pardon himself. And yes, I think that would run contrary to OLC's opinion about presidents pardoning themselves, but then who really cares about OLC? He can just appoint his own OLC head to change that particular ruling. There could be damaging information in there that concerns the Trump regime, perhaps about who was allowed access to these highly sensitive national security documents, what his intentions may have been with the documents, who he wanted to show them to, and how generally that could look pretty bad for his handling of national security information and intelligence information, which the people he has chosen to appoint to positions might be similarly inclined and or incompetent to manage these documents in a way that would keep them secure and protected. So that could become ammunition or fodder for questioning those nominees if they get to a questioning period by the Senate. That's something Trump personally may not care at all about, or maybe even lacks the kind of mental capacity to understand the significance of it. But the powers that stand behind him, and make no mistake, there are some pretty smart, nefariously intentioned people that stand behind them. They understand that that kind of questioning or scrutiny could slow down or make more difficult the confirmation of their picks or cause retroactive criticism for them, which could just generally impede their ability to get the regime's agenda done as fast as they'd like to. A second thing that could be a problem here would be whether more information about this might indicate potential criminal culpability for some of the players within the new government, people like Trump's chief of staff, who was perhaps implicated in that election interference investigation. Now, it's absolutely true that Trump's DOJ isn't going to do anything about that. They're, not going to charge anybody. But having a bunch of very damning information come out about them can, again, slow down the process, give more ammunition to those who are opposed to the qualifications or the character of these picks, and therefore that could cause a further political problem for Trump. Again, legally, probably nothing would happen because it's his DOJ. Also, by the time his term is over, there probably would be a statute of limitations issue. But I think the key here is we want to force as much as possible everything into sunlight. Make the Trump regime fight for the reports to be suppressed, so it's obvious they want to keep it suppressed. Make them go to the Supreme Court. Make the Supreme Court come up with a rule that makes it obvious that they, the court, want to help Trump keep it suppressed. We can all ask these questions, and as should Democratic representatives ask the questions of, if you really have nothing to hide, if this was all nonsense, as Trump likes to say, it was a witch hunt, why not release it? Let the people see there is nothing there to be concerned about. Make it blatant. Make them do their actions in a very obvious way that says we don't want people to see the truth, and there should be a clamor from us, a clamor from our representatives, a clamor from representatives that have integrity to say, let the American people see those results. I mean, hopefully Merrick Garland lets them come out as raw as possible, not a bunch of redactions. Let the American people see that. I mean, we paid a lot of money for that work to be done. We deserve to get to see it. The Trump regime has the raw political power right now to do what they want, which includes giving them power over prosecutors and the legal system, because in our democracy, raw political power can be wielded that way over the legal system. We need to do some things down the road to the legal system to make things in writing that the raw political power would have a harder time overcoming. But for now, they can do that. What can we do? We can make them do it in sunlight. All right, that's it for now. Make sure that you do follow us on this channel. This is our opportunity, our new medium to be able to talk with you, to collaborate, to hear what you have to say. Tell me your ideas, tell me your viewpoints on it, and we will talk to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.